Madam Bertud, will I win this case?
Que tacet consentire dictitur el silencio ortuga. Scriptum affirmata permissiones no escritas que tacet consentire dictitur el silencio ortuga.
So what does it mean?
There's a lawyer next door.
Oh, I'm so sorry. I'll just go to the next door. I'm so sorry. Bye!
Modes of discovery, its meaning and its purpose. Discovery is a device employed by a party to obtain from the adverse party the information about the relevant matters in the case in preparation for the trial. This is to enable the parties to be consistent with recognized privileges, to obtain the fullest possible knowledge of this issue, the facts before civil trials, and thus prevent the trials to carried on in the dark. No more surprises.
The application of the rules on modes of discovery rests upon the sound discretion of the court. It is the duty of the courts to examine thoroughly the circumstances of each case and to determine the applicability of the modes of discovery, bearing always in mind the aim to attain an expeditious administration of justice. Also rests on sound judicial discretion the determination of the sanction to impose upon a party who fails to comply with the modes of discovery. This discretion carries with it the determination of whether or not to impose the sanctions attributable to such fault.
The Rules of Court provides 6 modes of discovery, from Rule 23 up until Rule 28. In Rule 23, depositions pending action. Rule 24, depositions before action or pending appeal. Rule 25, interrogatories to parties. Rule 26, admission by adverse party. Rule 27, production or inspection of document or things. And lastly, Rule 28, physical and mental examination of persons. As we move forward, we are going to highlight Rule 26, admission by the adverse party.
The Rule 26, admission by the adverse party, is a mode of discovery that allows one party to request the adverse party, in writing, to admit certain material and relevant matters which, most likely, will not be disputed during the trial.
In order to avoid unnecessary inconvenience to the parties in going through the recourse of proof before the trial, a party may request the other to admit the genuineness of any material and relevant document described in and exhibited with the request,
Or admit the truth of any material and relevant facts set forth in the request.
When a request is made, a party may file and serve the written request at any time after issues have been joined.
The best course of action for the party receiving a written request for admission is to submit a sworn statement to the requesting party.
The best course of action for the party receiving a written request for admission is to submit a sworn statement to the requesting party, specifically denying the matters of which admission is requested. Or, if it does not deny the same, to set forth in detail the reasons why he cannot truthfully admit or deny those matters. This sworn statement shall be filed and served within the period designated in the request, but which shall not be less than 15 calendar days from the service of such request, or within such further time as the court may allow. The effect to failure to file and serve a sworn statement of denial, each of the matters which an admission is requested shall be deemed admitted.
In a state of Ferdinand E. Marcos Sr. versus Republic, the court held that the request for admission can be the basis of a summary judgment. The request can be basis thereof when its subject is deemed to have been admitted by the party as a result of that party's failure to respond to the request.
To avoid the implied admission, the party requested may have the compliance of the filing and service of the sworn statement deferred. This deferment may be affected by the filing with the court objections to the request for admission. Compliance shall be deferred until such objections are resolved by the court.
In Section 3, Rule 26, any admission made by a party as a consequence of the failure to comply with the request is only for the purpose of the pending action and shall not be deemed on admission for any other purpose. Likewise, the admission cannot be used against the admitting party in any other proceeding.
Admissions made in the mode of discovery, whether express or implied, are not final and irrevocable. The court may allow the party making the admission to withdraw or amend the admission upon such terms as may be just. To effect the withdrawal, the admitting party should file a motion to be relieved for the effects of his admission.
The effect of not filing a written request for admission is that the party shall not be permitted to present evidence on facts that are material and relevant and which are or ought to be within the personal knowledge of the other party, unless otherwise allowed by the court for good cause shown and to prevent a failure of justice.
Madam Bertud?
No, I'm Attorney Berta Wannabe.
Oh, I'm so sorry. I'm just going to go to the next door. Thank you. Oh, bye. Tama na siguro. Oh, sorry. Ninong ko ba?
Ay, sorry, ano to? Okay na.
Ite. Katong ano nga liyok mo doon? Dagan nga liyok mo te.
Liwat ka lang.
Go.
Que facet consitivite dure inside sa tuga. Scriptum enfermat.
Go.
No, I'm attorney. Ay, sorry.
Ite.